If you own a business in Alberta and you don't have an estate plan that is accommodated for it, you might have a problem. Most business owners are great at running their companies, but might not be as great at planning what happens after them. Today I'm going to walk you through what happens to your business when you die and what you can do now to protect it and to protect your family. I'm Chad Graham. I'm a lawyer in Edmonton, Alberta. This video provides general information for educational purposes only and does not create a solicitor-client relationship. For specific advice to your situation, contact your lawyer. Well, here's what I see quite a bit in practice. A business owner has a great accountant. They've got a solid corporate structure. The books are clean. The tax planning is correct. But nobody's asked the question, what happens to everything if I get hit by a bus? Morbid, I know, but we've got to deal with real life. Our business plans and our succession plans are often built separately, and we don't realize we need to connect the two. The will might say one thing, for example, and a shareholders agreement, if there is one, might say something different. The corporate tax structure has implications that the will might not comprehend and may impact what you want to do with your things. And it is in this disconnect that families can lose a family business. Not because the business isn't profitable, not because the market turned, but because the legal and tax framework weren't set up properly to handle this transition. This video is about closing the gap. Okay, so what happens when you die? Well, your shares in a corporation don't disappear. They become part of your estate. Your executor steps into your shoes as shareholder, but this is very important. Only as shareholder, not necessarily as director and officer. And this distinction matters. Owning shares gives you an economic interest in the company, but it doesn't automatically give you rights to run it. Directors manage the corporation's business and affairs under the Alberta Business Corporations Act or other act. If the deceased was the sole director and the sole shareholder, there's an immediate governance problem. The corporation has no one legally authorized to make decisions until the estate is ministered and new directors are appointed. For a sole proprietor turned incorporator, which describes an awful lot of small business owners in Alberta, this can freeze business entirely. Employees can't be paid, contracts can't be signed, clients can't be served. The business bleeds value every day. This gap persists. If there are multiple shareholders, the dynamic is different but still complicated. The surviving shareholders may not want the deceased spouse or children as new business partners. The estate may not want to be a minority shareholder in a company it doesn't understand. Everyone's interests can diverge at this point. This is why shareholders agreements, corporate wills, and buy-sell provisions are very important. A corporate will is a great solution for a sole owner, and a shareholder agreement is an essential solution for a joint owner of any business. Let's deal with the second first. A well-drafted unanimous shareholders agreement will address what happens on a shareholder's death. The typical structure is a mandatory buyout. When a shareholder dies, the surviving shareholders or the corporation itself are required to purchase the deceased shares at a price determined by a pre-agreed formula or with an independent valuation. This gives the estate liquidity, it gives the surviving shareholders certainty, and it provides a framework for transition. If you're a business owner with partners, but you don't have a shareholders agreement, or your agreement doesn't include appropriate buy-sell provisions upon death, that's a gap you need to close today. It's one of your most important corporate documents you'll ever sign, right alongside your will. And if you've ever built a successful business in Alberta, at some point your accountant is going to throw up two words at you: estate freeze. Here's the concept in plain language. An estate freeze restructures the share capital of your corporation so that you, the current owner, holds shares with a fixed value equal to the company's current worth. New growth shares, typically common shares, are issued to the next generation, a family trust, or new shareholders. You keep control, you keep the current value. But the future growth happens in someone else's hands at a lower tax cost. Why does this matter for estate planning? Because when you die, there's a deemed disposition of all the shares you own at fair market value. The CRA treats it as if you sold and reacquired your shares on the day you die. If your company has grown significantly since you acquired all those shares, the capital gains and the resulting tax bill, why, it can be enormous. An estate freeze caps your exposure. But it is definitely not a do-it-yourself project. It involves share reorganizations and some complex planning, coordination between your lawyer and your accountant. I do this work regularly for Alberta businesses and for families. And if your accountant has raised this idea with you and you're not sure about how it all works out legally, give me a call. It's a conversation worth having. Now, I mentioned earlier a corporate will. This is a document that passes outside of the probate process and separate from your personal will. It allows your executor to immediately vote your shares and to appoint either themselves or someone else to be a director or officer in the company, to get bills paid and to get things moving. This is not an ideal solution in every case, but it might be an ideal solution in yours. It's a conversation worth having. Now, as a practical question, if your shareholder agreement says that surviving shareholders are to buy out the deceased shares, where would that money come from? Well, one solution is life insurance. Each shareholder takes out a life insurance policy on the others, or the corporation does, and the purchase is automatically made. Succession planning is different from estate planning. People use the terms interchangeably, but they are simply not the same. Estate planning answers the question, what happens to my assets when I die? Who inherits? Who manages the estate? How do we minimize tax? Succession planning answers a very different question. What happens to my business when I step away? Whether that's retirement, disability, or death. Who runs it? How does it transition? And how do we preserve the value that I've built? They overlap, but they're not identical. You can have the perfect estate plan, a well-drafted will, an executor, a clear distribution scheme, but still have no succession plan. Your family might inherit the shares, but nobody knows how to run a company. Clients leave, employees leave, the value evaporates. A real succession plan will address all these issues. And the best time to start succession planning is now, 10 years before you need it, 20 years before you need it. Key person risk is really important. This is the most difficult thing that these sole proprietor business owners have. If the business depends on you entirely, your relationships, your expertise, your reputation, then when you're gone, the business may not have transferable value. Even if it's incorporated and the shares exist, what are they worth without you? Now, this doesn't mean your business is actually worthless, but it does mean you need to think about the business value independent of you and plan for it now. Business owner estate planning is not a one-person job. It requires coordination between your lawyer, your accountant, and your financial advisor. Your accountant will handle the tax analysis, the deemed dispositions, the capital gains exposures, the estate freeze mechanics, the corporate tax filings. Your financial advisor could help you with insurance, key person policies, buy-sell funding, and overall risk management. But your lawyer is going to handle the legal structure, the will, the shareholders agreement, the corporate will, and any corporate reorganizations, the trust deed if a family trust is involved. And these three professionals need to be talking with one another. They need to be people who are used to working in this area and understand succession planning. The shareholder agreement needs to reflect the insurance structure, for example. The will needs to be consistent with the shareholders agreement. The estate freeze needs to be coordinated with the tax plan. If any of these are done in isolation, gaps will grow. At Chad Graham Law, we do both corporate and estate planning work in-house. That means your shareholder agreement, your will, your corporate reorganization, your estate freeze if it's appropriate, all going to be built by a lawyer and legal team that understands the full picture. If you're a business owner in Alberta and your estate doesn't yet plan for the accounting for your business, now's the time to fix that. There is a link in the comments that you can go to book a consultation with me.